Today we'll be talking to you about the Eschede train disaster and how it relates to ethics and legality. To summarize the event, in 1988, German company DB introduced their first advanced high-speed train, the ICE-1, that stood for Intercity Express. Early issues with the train wheels regarding unpleasant humming and vibrations were resolved through a subpar, cost-effective wheel design. 5 years later, a tram operator warned DB about the new wheels breaking before their rated life and about shortening the replacement intervals. DB denied the claim and responded by referring to the many improvements of the new wheels. On June 3, 1998, ICE-1 car 151 was approaching Eschede when a tire of the first passenger car snapped due to undetected fatigue cracks and pierced the cabin floor, nearly missing 2 passengers. The conductor was unable to trigger the emergency stop in time, and the train derailed, sending it 200 km per hour sideways into a concrete overpass. The incident killed 101 people and injured 194. Investigation proved the calculations for the metal tire lifespan were done incorrectly and proved the necessary maintenance was not performed. After the ensuing legal affairs, by 2008, DB voluntarily paid $38.8 million in damages and other costs to the passengers and their families.
Now let us examine the ethical and legal issues of the engineers involved from a Professional Engineers Ontario view. First, the engineers came up with three solutions to the problem: changes to the track, air suspension for the wheels, or using slow tram wheel technology. The engineers were notified by their executives to not exceed cost or time and used the third option. The slow tram wheel technology was not fit for the high-speed trains. Therefore, the engineers failed professional misconduct by Code 72.2.b, failure to make reasonable provision for safeguarding of life, health, or property of a person who may be affected by the work of the practitioner, and 72.2.f, failure of a practitioner to present clearly to the employer the consequences expected from a deviation in their work. Additionally, they failed the Code of Ethics 77.2.i, regard the practitioner's duty to public welfare as paramount. Next, the engineers omitted the standards for high-speed tests when completing testing for the new wheels. They only used low-speed tests when the train actually went well above these speeds. By omitting these tests, the engineers failed professional misconduct by Code 72.2.8, omission in the carrying of the work of a practitioner that constitutes a failure to maintain the standards that a reasonable and prudent practitioner would maintain, and Code 72.2.b again.
The engineers were also notified by board members to end the testing early, even though the tests were not complete. By ending testing early, the engineers additionally failed Professional Misconduct Code 72.2F again. Finally, shortly after implementing the new wheel designs, an operator notified board members that the wheels were breaking before scheduled end of life. If the engineers knew that the wheels were failing, they would additionally fail Professional Misconduct Code 72.2C, failure to act to correct or report a situation that the practitioner believes may endanger the safety or the welfare of the public. Alternatively, the engineers should have taken the codes more seriously and refused to move forward with the project unless all the ethical concerns were met. This solution may have resulted in spending more money for the company, but would have saved the hundreds of lives that were lost due to the oversight. This illustrates how important it is as engineers to ensure we take the code of ethics very seriously and that we always put the well-being of the public above the monetary gain of a company. Now we can look at the legal issues in this study. We can see that this case would fall under tort law, where DB is responsible for the damage occurring in the accident. We can use the three-point test. Was the defendant owed duty of care from the plaintiff? Yes. Was the defendant failed by the plaintiff in this duty of care? Yes. Did the failure cause damage to the plaintiff? Yes. So now, to properly analyze this case using tort law, we can use preceding cases. One such case would be Donahue and Stevenson, which shows there is no contract needed for DB or the engineers to still be responsible for the safety and well-being of the passengers.
The engineers that were involved in this case were tasked with ensuring that the train will be able to operate properly. Whether or not the engineers were liable for the accident is brought into court. The court case went into detail about what orders the engineers and mechanics were under and if they followed procedures correctly when maintaining the train. After looking into the case, the court decided that the engineers did not go against their supervisor's orders, which deals with the idea of vicarious liability. Here, the executives were deemed as liable for how the engineers and mechanics handled the operation, as they were the ones who employed them for the task. In this case, the executives were in a position where they did not need to take any risks, and could have prevented the accident if they were more attentive. Tort deals with reverting back to the state as if the accident did not occur. The damages in this case include general and aggravated damage. Here the general damage includes the loss of life and injury from the accident, which is unable to be compensated monetarily. The aggravated damage is the distress that was done to the victims or families of the victims from the aftermath of the accident. There is also damage done to the surroundings and the train itself that requires compensation. The court's decision upon this case was to make DB pay reparations towards the people affected by this accident, which included survivors and families of the victims. The money was paid by 3 engineers, 2 of whom worked for DB and 1 from the wheel manufacturing company.